Hey, how's it going? There's been a lot of questions about the McClelland case, and I thought that I could just read the plaintiff's Second Amended Complaint. That's the most updated version, and it'll basically explain what's going on. I think that I've shared bits and pieces of what's been happening recently, and I think without understanding where it all got started, it can be a little bit confusing. So sit back, relax. If you appreciate me doing this, so you don't have to, I'll throw my Venmo up on the screen. If you want to throw me a few dimes out of appreciation, I would appreciate that. So here we go. In the United States District Court for the Southern District of Texas, Houston Division, Bronson McClelland versus Katy Independent School District. To the Honorable United States District Judge Keith P. Ellison comes now plaintiff Bronson McClelland and files his Second Amended Complaint and shows the court as follows. Introduction. Plaintiff is a former student and starting quarterback of Katy High School on October 3rd, 2019. After an emotional win against a rival football team, plaintiff regrettably used a racial slang term while off campus at a non-school related event. Katy ISD subsequently punished plaintiff by suspending him from 2 football games and removing him as captain for his off-campus speech, along with issuing a public statement about the discipline which falsely indicated plaintiff had sent the video directly to the opposing team's player. The U.S. Supreme Court recently held that a school district cannot discipline a student under these circumstances. Defendants' infringement of plaintiff's First Amendment rights did not stop there. In an effort to force plaintiff to leave Katy High School and thus rid the district of its self-perceived racial problem, defendants concocted a new complaint as pretext for punishing plaintiff. On September 17, 2020, defendants conducted a so-called random vehicle search whereby plaintiff's vehicle was singled out and searched. A search of the vehicle ultimately found 0.04 grams, roughly half the weight of a single peppercorn, of a, quote, green leafy substance on the back floor mat of the vehicle. Plaintiff was immediately placed in the school's Disciplinary Alternative Education Program, also known as DAEP, and plaintiff was informed by the district's general counsel that he would, quote, would never see the football field again at Katy High School. And that should he appeal, the district, quote, would drag this out until football season was over. After initiating an appeal of this unjust DAEP placement, Katy ISD determined there was a, quote, unusable amount, end quote, of a substance containing THC, while admitting that the district, quote, district did not test, end quote, the substance to determine if it was, quote, marijuana as prescribed by Texas law, end quote. Noting that, quote, Texas law requires that the district to consider 6 factors, which include the intent or lack of intent by the student at the time of the incident, end quote. Katy ISD, quote, determined that Bronson did not intend to possess the substance on campus, end quote. And as a result, any discipline was, quote, overturned, end quote, and, quote, no disciplinary matters were pending, end quote. At this point, Katy ISD exercised their discretion and authority under Texas law, found that not a single element of the offense was established, and issued the district's final determination of exoneration. Plaintiff then attempted to transfer into another school district to avoid the continued harassment from defendants. Plaintiff's attempts to transfer into another school were unsuccessful, partly due to the erroneous transcripts sent by Katy ISD, and he returned to Katy High School. Upon re-enrolling at Katy ISD, the school district rescinded, without any legal authority, their already final appeal determination that exonerated plaintiff and again forced plaintiff to return to DAEP. The continued harassment and punishment plaintiff received for his off-campus speech violates plaintiff's rights. Plaintiff seeks injunctive and declaratory relief, as well as monetary damages. 2, these are the parties. Plaintiff Bronson McClelland, here I'm referred as plaintiff. I'm going to skip over this. Ken Gregorski, Justin Graham, Rick Hull, Leslie Hack. 3, jurisdiction and venue. That's kind of boring. Let's get to the facts. Plaintiff Bronson McClelland is a good student and talented athlete. By autumn of 2018, plaintiff was the starting quarterback of Katy High School's varsity football team. Katy High School's football program is an elite program regularly advancing deep in the Texas high school playoffs and is coached by Gary Joseph. As a function of being an athlete in an elite program and in such a high-profile position, plaintiff has been subjected to numerous drug tests during his playing career and has never tested positive for any banned substance, including marijuana. To participate in varsity athletics at Katy High School, plaintiff was required to sign an athletic code of conduct, which required, among other things, that he conduct himself as gentlemen and ladies at all times, exhibit good citizenship at all times, and display model behavior associated with positive leaders both in the school and in the community. A true and correct copy of the athletic code of conduct is attached herein as Exhibit 1 and incorporated by reference. A school district has the right and obligation to promulgate and enforce rules that are consistent with Texas law. The Texas legislature provided in relevant part that, quote, a student shall be removed from class and placed in a disciplinary alternative education program as provided by section 37.008 if the student sells, gives, or delivers to another person or possesses or uses or is under the influence of marijuana, that's a weird spelling, or a controlled substance as defined by chapter 481, Health and Safety Code, or by 21 USC section 801. Texas Education Code, section 37.006A2CI. Consistent with Texas law, Katy ISD adopted the above language from the statute into its rules verbatim, as they do. Neither Texas law nor the Katy ISD Discipline Management Handbook provide discretion to disregard any element contained therein. Specifically, the statute listing the elements of the offense of marijuana possession requires, quote, the person knowingly or intentionally possesses a usable quantity of marijuana, end quote. Texas law further exempts, quote, hemp, end quote, from its definition of, quote, marijuana, end quote, meaning that cannabis with 0.3% concentration or less of tetrahydrocannabinol, THC, may be lawfully possessed. The Katy ISD Discipline Management Handbook incorporates by reference these provisions. The 2019 incident. On October 3rd, 2019, the Katy High School football team quarterbacked by plaintiff McClelland defeated crosstown rival Tompkins High School 35-31. Later that night, following the victory, students from both schools went to a local Whataburger restaurant where students from rival Tompkins High were taunting students from Katy High School in person and through Snapchat. Plaintiff and several teammates arrived to support their friends. Snapchat is a social media application for smartphones that allows users to share temporary images and videos which are meant to disappear after the recipient has viewed it. The images and videos can be sent to a single individual, to selected friends, or can be posted to the user's, quote, story, end quote, where only friends of the user can see the story for 24 hours. Through a video in Snapchat, plaintiff responded to the taunts from a student from the opposing school, and during such response, used the slang term in **A. Plaintiff's video was then sent from the Snapchat account of his friend to a single individual, Jose Hernandez, a student at Tompkins High, but not a member of the Tompkins High School team. Plaintiff's Snapchat was approximately 3 seconds long. Plaintiff did not create, access, or share the Snapchat at school or at a school event, nor did plaintiff use school resources to create the video. Plaintiff and Hernandez had a single in-person exchange that night from a distance inside the Whataburger, after which each followed up their taunts and bravado through social media. Upon receiving the video for unknown reasons, Hernandez then recorded the Snapchat video and sent the video to several of his friends. Eventually, Tunmais Adelaide, an African-American football player from rival Tompkins High, received the video. Upon receipt of the video, Adelaide uploaded it to his personal Twitter page, giving the illusion or appearance that McClelland sent the video to Adelaide. On October 4th, 2019, Coach Joseph called plaintiff's father to discuss the video, which was rapidly circulating and causing a public relations issue for Katy High School and Katy ISD. At approximately 11:30 a.m., plaintiff and his parents met with Coach Joseph and Hull at Katy High School. Coach Joseph and Hull stated plaintiff was going to be disciplined for his off-campus speech in the video, and that the issue would be addressed at the school rather than the district level. Hull and Coach Joseph determined that plaintiff would be suspended from playing in the following 2 games and that he would be stripped of his position as captain of the football team. Effective immediately and prior to any investigation, defendants contend they conducted. Following the meeting, plaintiff and his family discussed the situation, and plaintiff decided to release an apology immediately. Prior to releasing his apology, plaintiff's father notified Hull and Coach Joseph of its forthcoming release on McClelland's personal Twitter account. Plaintiff released his apology, which stated in full, quote, "After last night's win over the Tompkins Falcons, I made comments on social media that were not appropriate under any circumstances. Being in a leadership role, I put my family, teammates, coaches, school, and community in a bad light. Today, my parents and I met with Coach Joseph to discuss my actions and that poor decision. I will no longer have a leadership role as a team captain and will not participate in the next 2 district games, giving me time to focus my attention on what it means to be a Katy Tiger. I ask for your understanding and support as I try and represent you in the manner expected from a member of a championship program. Bronson." End quote. Approximately 75 minutes following the release of the apology, Hull contacted plaintiff's father demanding to have the statement removed or revised to state plaintiff had been, quote, "suspended indefinitely," end quote. Despite the fact that the statement accurately reflected the discipline received just hours prior. When asked why he was demanding such action, Hull said, "so that it did not appear that Hull and Katy High School rushed the investigation." Plaintiff refused to revise or remove the statement. Shortly thereafter, plaintiff's father received a call from Coach Joseph demanding once again for the apology to be completely removed or amended at the request of Katy ISD, despite the accuracy of plaintiff's statement. Plaintiff again refused. At approximately 4:45 p.m., Katy ISD released a statement. In it, Katy ISD claimed it had conducted a thorough investigation and determined the plaintiff, quote, "used racially charged language to taunt a student athlete on the opposing team," end quote. And that, quote, "the student responsible will face disciplinary consequences," end quote. As a result, a true and correct copy of the Katy ISD statement is attached herein as Exhibit 2 and incorporated by reference. When Katy ISD, through Hack and Hull, released the Katy ISD statement, it was aware that the video was not made for or sent to any, quote, "student athlete on the opposing team," end quote, by McClelland. Katy ISD intentionally took the video of plaintiff out of context, promoting the false narrative that plaintiff was a racist, and notified the media and general public that plaintiff would be punished for his off-campus speech. On or about October 7th or 8th, 2019, Coach Joseph held a team meeting to discuss the discipline being given to plaintiff. Coach Joseph acknowledged and took a measure of responsibility for the language used in the video, specifically use of the racial slang. Coach Joseph confirmed with the team that he frequently heard them use the, quote, "N-word," end quote, at practices and in the weight room, and had ignored and tolerated it. Therefore, Coach Joseph implemented a new rule that going forward, use of the, quote, "N-word," end quote, in any form was forbidden at on-campus and school-related activities that he supervises. Prior to October 4th, 2019, no other Katy ISD student athlete had been disciplined for the use of the, quote, "N-word," end quote, on campus or at school-sanctioned events, much less for using the slang term in off-campus speech during personal time. On October 7th, 2019, McClelland's parents met with Coach Joseph and Hull. During this meeting, Hull acknowledged he heard plaintiff state the video was sent to a, quote, "Jose," end quote, during the previous meeting on October 4th, rather than a player on the opposing team as falsely stated in Katy ISD's press release, and that he was unaware Katy ISD was going to release the Katy ISD statement. Plaintiff's parents stressed that the statement was false and damaging to plaintiff's reputation and would negatively impact his future opportunities and his ability to be recruited for college sports. On October 9th, 2019, plaintiff's parents met with Hack, who acknowledged that she was unaware of all the details of the incident, yet admitted she approved of the release of the statement. During this meeting, the McClellands again emphasized that the video was not sent by plaintiff to, quote, "taunt a student athlete on the opposing team," end quote, as reported in the Katy ISD statement, and that such inaccuracies makes it look like the message was racially motivated and directed at an African-American player. Hack informed the McClellands that it was Hull who provided the information for the press release. The McClellands stated their demand that the record be corrected by Katy ISD by issuing a new, accurate statement. Later that day, Hack called plaintiff's father and told him, quote, "At this time, they would not be issuing a new statement because we cannot locate Jose Fernandez to verify Bronson's claim that he sent the video to Jose," end quote. Later that evening, plaintiff was able to positively identify the recipient of the message as, quote, Jose Hernandez, end quote, rather than, quote, Fernandez, end quote, as searched for by Katy ISD. Furthermore, plaintiff received written confirmation from Hernandez that the message was sent directly to him, and then a then student at Tompkins High School, non-football player of Hispanic origin, and that the video was not sent to Adelaide by plaintiff. On October 10, 2019, McClelland's father sent notice to Hack and Hull regarding the identity of Jose Hernandez. Despite this confirmation and proof that the Katy ISD statement misstated material facts, Katy ISD refused to retract or correct their inaccurate statement. Over the following 11 months, McClelland exhausted all administrative procedures seeking to have Katy ISD correct its false statement regarding plaintiff. Plaintiff, who was being actively recruited to play NCAA football at several large universities, had the recruitments suspended as a result of the Katy ISD statement, which stated that he, quote, used racially charged language to taunt a student athlete on the opposing team, end quote. Plaintiff has been told from these schools that he would not be recruitable until each such statements were rescinded or corrected. On September 14, 2020, after 11 months and several prior extensions, Katy ISD sought another extension to respond to plaintiff's demands to resolve the false statement issue. Plaintiff gave Katy ISD an extension for a decision until September 18, 2020, after which time plaintiff indicated he would pursue legal remedies. On September 17, 2020, the day prior to Katy ISD's deadline to resolve the 2019 issue regarding misstatements about plaintiff contained in the Katy ISD statement, the vehicle shared by plaintiff and his older brother were allegedly identified by a Katy ISD police canine unit in a so-called random search. Katy High School was notified and summoned plaintiff to his vehicle, whereby he notified Katy ISD police officer Stephanie Fulgencio that he shared the vehicle with his older brother. At approximately 9:15 a.m., Fulgencio supervised the search of the vehicle in the Katy High School parking lot by Katy ISD police officers. Upon being asked about the substance by Katy ISD police, plaintiff denied ownership or possession of the substance or knowledge of the presence or nature of the substance. Following the search, Fulgencio informed Ashley Darnell, the assistant principal of Katy High School, that a substance had been found in plaintiff's vehicle, with Fulgencio later specifically noting multiple times in her official report that it was not a, quote, usable amount, end quote, and in fact was so minute that it would not even register on her electronic scale. Darnell conducted an initial inquiry with plaintiff in which he reiterated that the substance found was not his, that he had no idea what it was, and that he shared the vehicle with his college-age brother. Darnell, on behalf of Katy High School and Katy ISD, charged plaintiff with possession of marijuana in violation of Texas Health and Safety Code, Section 481.121. At the time of her decision to charge plaintiff, she had been informed unequivocally that the substance was not a, quote, usable amount, end quote, and she knew that the substance had not been tested to determine its THC potency. Plaintiff was immediately suspended for 3 days and sent to the Disciplinary Alternative Education Program, also called DAEP, for 45 days. On September 18, 2020, following Darnell's initial decision to pursue discipline against plaintiff, Hull held a disciplinary hearing. At the hearing, Hull was informed of the facts of the incident, including A, that only 0.04 grams of the substance was located, which was an, quote, unusable amount, end quote, and B, Fulgencio explained to plaintiff and Hull with great specificity that Texas law had changed in 2019 regarding the legality of hemp and marijuana. Since that change for a substance to now be considered unlawful, quote, marijuana, end quote, it must contain a THC level of greater than 0.3% potency. She further stated unequivocally that a THC potency test must be conducted in a laboratory. Fulgencio specifically stated that a presumptive field test was not able to make the THC potency level determination as required by law. Despite these admonitions, Hull determined without any THC potency testing and disregarding the usable quantity, quote unquote, requirement that plaintiff was in fact in possession of marijuana, and initiated the process required to transfer plaintiff to DAEP. Keeping my thoughts to myself. On September 21st, 2020, upon a request from Hull, Fulgencio conducted a presumptive field test on the substance at the Katy ISD Police Department. After Fulgencio conducted the field test, which would only determine the existence of THC but not its potency, Fulgencio reported her findings to Hull, and he authorized the transfer of plaintiff to DAEP. Therefore, Fulgencio and her supervisor, Assistant Chief Kevin Tabor, prepared a Katy ISD supplemental police report, a government record. In this report, Fulgencio and Tabor knowingly and falsely included the conclusion that the substance had a, quote, presence of THC. This was in fact marijuana, end quote. This statement was made while Fulgencio and Tabor knew that the substance had not been properly tested to determine if its THC potency exceeded the legal threshold for, quote, marijuana, end quote, or if it was lawfully, quote, hemp, end quote. This falsified police report was used as evidence against plaintiff by Katy ISD, Hull, Gregorski, and Graham. On September 21st, 2020, Katy ISD, Hull, Gregorski, and Graham disciplined plaintiff by sending him to DAEP for 45 days, effectively ending his high school football career. Following his placement in the DAEP, plaintiff, through counsel, immediately began the process of appealing the decision to Katy ISD, which was reviewed on appeal by Gregorski, Katy ISD's superintendent. During conferences between McClelland's counsel and Graham leading up to the determination of the Gregorski appeal, Graham stated to plaintiff's counsel that, quote, Bronson McClelland will never again see the football field for Katy High School, end quote. And, quote, if the family fights Katy ISD on this, we will drag it out until football season is over, end quote. Plaintiff knew he would never be treated fairly by Katy ISD, which became his sole reason for leaving the district. On September 28, 2020, Katy ISD, through its superintendent Gregorski, signed a letter ambiguously titled Discipline Appeal. It provides the following: September 28, 2020, Discipline Appeal. I'll just read it. Dear Mr. McClelland, this is letterhead. Well, there's no letterhead. It's to Colburn McClelland. Dear Mr. McClelland, as is required at Katy ISD, the district has reviewed the alleged conduct of Bronson McClelland on September 17, 2020. In reviewing such discipline, Texas law requires that the district consider 6 factors, which include the intent or lack of intent at the time the student engaged in the conduct and the student's disciplinary history. In light of these provision, I have determined the following. On September 17, 2020, the district conducted a routine search of one of our high school parking lots. During that search, the canine alerted the vehicle driven to school by Bronson McClelland. That morning, a search of the vehicle found an unusable amount of substance that was field tested to contain THC. However, the district did not test the substance to determine whether the requisite amount of THC was present that would have indicated the substance was in fact marijuana, as prescribed by Texas law. During the campus-level hearing, Bronson denied that the substance was his, and his older brother came forward to give his account. His brother had recently totaled his personal vehicle and was temporarily using Bronson's vehicle. His brother admitted that the substance was his. Unlike Bronson, the brother has a history of marijuana-related incidents and charges which are well known. Bronson did not have any past drug-related charges or incidents that the district is aware of. As such, I have determined that Bronson did not intend to possess the substance on campus. Therefore, the discipline given to Bronson McClelland on September 17, 2020 is overturned and no disciplinary matters are pending. Signed, Dr. Ken Gregorski, Superintendent, Katy Independent School District. A copy of the letters attached herein as Exhibit 3 and incorporated by reference. In the Gregorski appeal, the district, quote unquote, engaged in a, quote, review, end quote, of the incident involving plaintiff, and the, quote, the district, end quote, has, quote, determined, end quote, that there was no intent to possess the substance and that the discipline was, quote, overturned, end quote. The Gregorski appeal is a, quote, decision of the board's designee, end quote, which is the only appeal authorized by Texas law, end quote, final, end quote. The Gregorski appeal language follows the precise elements of possession of marijuana as provided in Texas Health and Safety Code, section 481.121. On September 29, 2020, after Katy ISD, through its superintendent Gregorski, had already, quote, determined, end quote, plaintiff had not violated Texas Health and Safety Code, section 481.121, for possession of marijuana, plaintiff and Katy ISD entered into a settlement agreement whereby plaintiff was provided a copy of the already determined Gregorski appeal and a commitment from Katy ISD and Gregorski to ensure Katy ISD directed employees to prepare certain government forms indicating that the plaintiff was not subject to discipline. Plaintiff, under the settlement agreement, agreed not to sue Katy ISD for any reason and to leave the district. A true and correct copy of the settlement agreement is attached herein as Exhibit 4 and incorporated by reference. The settlement agreement specifically required the district to, and this is from the agreement, number 2, the district agrees to provide the family with the attached letter concerning the status of the discipline. If asked about discipline by another education institution out of the state of Texas, Katy ISD will refer them to the letter and indicate that no discipline consequences remain. 3, the district agrees, where requested, to also have the district's athletic director, Katy High School's head football coach, and Katy High School's principal execute the 2 attached documents that indicate there is currently no disciplinary proceedings pending between Katy High School and the family. That's the end of that document snippet. Katy ISD and Gregorski specifically commit the district to refer any third-party school districts to the Gregorski appeal determination letter and to prepare government documents indicating that there is no discipline pending. At the time the settlement agreement was executed, Katy ISD, Gregorski, Hull, and Graham were aware that any discipline pending or deferred would continue to apply to the student if the student transferred to another school district in the state. Thus, Katy ISD, Gregorski, Hull, and Graham were aware they were representing to districts both in-state and out-of-state that the disciplinary issue with plaintiff had been, quote, overturned, quote. On appeal, plaintiff was exonerated and the decision was, quote, final, end quote. Plaintiff first attempted to transfer from Katy High School to a school in California. He was unable to do so as a result of Katy ISD providing erroneous transcripts to the receiving school. Therefore, on October 8th, 2020, plaintiff enrolled in Manor Senior High School, Manor, Texas, and sought to have his eligibility to play varsity sports reinstated. Under Texas law, when a student in Texas is transferring from one Texas public school to another Texas public school and wishes to participate in school athletics, the multi-section university interscholastic league previous athletic participation form, the PAPF, must be completed by the outgoing school, the transfer recipient school, the student, and the student's parents. On October 9th, 2020, Coach Joseph, at the direction of Gregorski, Graham, and Hull, completed Katy High School's portion of the PAPF to facilitate plaintiff's transfer from Katy High School. Coach Joseph indicated no disciplinary issues or any reason McClelland could not participate. And you can see the document here. Under checkboxes, the no checkboxes for was this student ever suspended or removed from your school athletic program? If yes, attach explanation to DEC. Also checked no. Number 5, would the student be prohibited from participation in athletics had they not changed schools? If yes, please attach explanation. Signed by Gary Joseph, October 9th, 2020. A true and correct copy of the PAPF is attached hereto as Exhibit 5 and incorporated by reference. On October 29th, 2020, after being denied eligibility by UIL to participate in athletics at Manor High School due to residency requirements, plaintiff re-enrolled in Katy High School. Despite having received exoneration for the marijuana possession allegation in the Gregorski appeal, Katy ISD initiated a new appeal, apparently challenging its own decision, which had, quote, determined, end quote, plaintiff did not violate Katy ISD's policies in Texas Health and Safety Code, Section 481.121. Although plaintiff's counsel objected, Gregorski, Hull, and Graham initiated an additional appeal on November 6, 2020. At the hearing, plaintiff sought to introduce the discipline appeal, quote unquote, letter signed by Gregorski on behalf of Katy ISD. Graham, acting in a quasi-prosecutorial judicial role, determined that the Gregorski appeal decision would not be discussed, and the PAPF form would not be admitted, and directed the 3-member panel to ignore the exoneration letter. The new, quote, appeal, end quote, determined that plaintiff had violated Texas Health and Safety Code, Section 481.121, for possession of marijuana, knowing it was not a, quote, usable quantity, end quote, without having tested the substance for its THC content and ignoring the intent element as required under Texas law, and in direct conflict with the determination of the Gregorski appeal. As a result of the unlawful second appeal hearing, plaintiff was placed back in DAEP and prevented from I, returning to Katy High School, and I, ever returning to the football field his senior year. Plaintiff finished high school assigned to the DAEP, graduated in December 2020, and is now enrolled in junior college. So the rest of that goes into the specific violations and damages, and I think that gives enough of the story. I'm going to hold my opinion to myself, and curious what you guys think. So we'll keep you updated as new filings come through. If they're relevant and important, I'll be sure to share them. Okay, bye.